Thank you very much, and once again thanks for the invitation to take part in this very interesting discussion. In the opening panel, we of course heard a lot about sort of the challenges, and I would also say we talked about the weakening of the normative power of the Union. I would say that what I see is a very contradictory picture. I mean, there's a lot of contradictory flows currently in the US, I guess there's always. And what I would like to focus on is actually what are some of the possibilities and how can we actually use these possibilities more. And if I allow me to start with my conclusion. My conclusion is that we don't need, in my view, at this stage, new procedures, new institutions. Number of procedures, institutions are in place, but use them. They can be optimized in their functioning, they can be used much more by civil society and other actors. There's still a vast landscape out there which I would say is unexplored by many of the key actors who sort of want to preserve fundamental rights and the democratic framework of the Union. Let me start by just also outlining, as I did in my short comment before, on the framework. What are the limitations? And I'm not going to read all the limitations, but it is important to recall always that with candidate countries we have the Copenhagen criteria. There is a general perception that the moment a candidate country turns into a full member, then basically things can only move forward. It is not really perceived that things can slide backwards in the way that the institutions are given their mandates and the whole thinking that as it has pervaded. At the same time, we should not forget that those elements that we're talking about here are core to the state sovereignty. So in any international collaboration, there will always be strong hesitations from any state to give powers to any supranational body, whether it's the Council of Europe, the EU, anywhere to look into the electoral systems or whatever the systems may be. Human rights, there have been sort of what you say, the everyday sort of human rights elements. There have been more openness after, say, the 1948, the Universal Declaration, recognition that we need to have an openness and instruments in place. And we have the UN, Council of Europe, and other mechanisms. So this is some of the framework that we always have to recall when we discuss these issues. And it also underlines why we cannot only speak about the EU, but also about the Council of Europe. One interesting side effect of the discussions regarding Hungary is that actually the EU institutions, particularly the Commission, which before the discussions on Hungary, rule of law issues in relation to Hungary, I would say broadly were not too respectful to the Council of Europe, did not really see the value of the Council of Europe. But when they certainly recognized their own limitations and they saw that some of the instruments actually could be found in Strasbourg, be it in particular, of course, the Venice Commission, the relation between the Union and the Council of Europe was strengthened, and the interaction has in many ways much well, let me just highlight some of the mechanisms that I saw from my previous position as Director of the Fundamental Rights Agency. First of all, in the lawmaking, let me just, before I enter into that, say that when we talk about these issues, it's also important to always remind ourselves that there's no one step that fixes all the problems. If we want to create a true fundamental rights culture, there are so many different elements, different dots, whether it's independence of courts, minority protection, combating discrimination, prison conditions, penal law issues. All these different dots is what sort of makes up the democratic state and create a human rights culture. And that's why, and that's where it gets complex and tedious. We have to keep an eye on all these developments. You can of course sort of say, identify some key indicators, what is in particular of importance, and I like very much concur with your list of priorities. Also mentioned, of course, civil society, independence, of course. But what have we got here? We have, for example, the the development now following the Charter of Fundamental Rights becoming legally binding. We are now in the process of adopting in the Union a new internal security strategy. And for the first time we now see the Union using the language of fundamental rights by design. So basically now taking fundamental rights much more serious in the sense that human rights are being taken on board from the very outset of creating new strategy, creating new legislation, and not either totally sidelining it or putting it on towards the very end. This came of course from the eye-opening effect of the court's decision last year in relation to the retention directive. That really pushed a new agenda that we all need to follow very closely in order to feed in to the legislative and policy processes. What are then the issues that should be taken into consideration when this new piece of legislation is being designed? And here again, experts, civil society and others can play a much more active role than they do hitherto. Then we have the draft legislation being tabled at a certain stage. Here the Fundamental Rights Agency has numerous times been asked by the Parliament and the Council to give its legal opinion on the legislation, the conformity with the Charter and Fundamental Rights Agency. Again, that has had quite an impact on those pieces of legislation. Again, the Fundamental Rights Agency need in that regard a stronger mandate because it can only do it today upon request from one of the institutions and not on its own initiative, and that definitely should be brought in place. Then the next steps are the whole implementation, the monitoring of the implementation by member states of directives, policies, where I know from, let's say, at least the previous commission, we still have to see the new commission, but the previous commission was rather open to receive information, but very often complained that they didn't receive sufficient information from civil society, from other actors in member states, or where are the problems in relation to the implementation of this or that directive. So again, play in here. The infringement procedures that we have touched upon, France, in relation to the Roma that was opened in summer 2010, had a tremendous impact, not only in France but also in other member states which were sort of warming up to take the same sort of steps vis-à-vis the Roma, returning them mass expulsions to member states, back to where they came from. They basically blocked it the moment the Commission opened its infringement procedures, and we know that France then took some steps. Whether it was sufficient, etc., absolutely not. There are still big problems, but at least it indicated let's say the strength of the infringement procedures, as well as, of course, the Hungarian cases. We know that you mentioned that with the judges, and in particular, it also raised the data protection officer, the independence of the data protection officer. But I think, again, the Hungarian case also illustrates the weakness of the system, in the sense that the Commission had to open the case in relation to discrimination. We could say this was a major, I want to say, erosion of a democratic institution, and the tool that was available was discrimination, age discrimination, which of course illustrate that weakness of the mandate of the Union. Let me move on to the rule of law. We now have the rule of law framework of the Commission has not been used. It's being challenged by the Council, by member states, again illustrating, let's say, the sensitivities. And this is not only by challenged by, you could say, the usual suspects, but there's quite a few member states actually not too pleased with that framework. We'll see what the Commission will do with it. We still haven't really heard from the new Commission in this regard. But again, I would say the civil society, other institutions, academia can play in here. I'm conscious about time, and I want to say a few words about the Fundamental Rights Agency and its particular role. The Fundamental Rights Agency has, in one way, a strong mandate, and the same time there are limitations. Where it's strong is that it contributed within the mandate to actually demask for the first time some severe challenges in Europe. And I will in particular point to that we for the first time demasked the level of hate crime. Hate crime being one of the drivers of extremism, radicalism in Europe, an issue that has been grossly neglected by, I would say, 9/10 of the member states. Few member states have previously taken it serious, but it is really one of the crimes that contribute to eroding the social cohesion in our society, because it injects tremendous fear in our minority groups, whether it's ethnic minorities, religious minorities, whether it's sexual minorities and others. Now, based on what the agency was, all ministers of Interior and Justice are now sitting around the table of the ministries to actually see and move on that agenda, which is extremely important. Economic social rights has been raised here in the upcoming annual report from the agency. There will be a focused chapter which normally is also being read very carefully, where we highlighted, I was very much involved in it, the importance of including economic social rights in the austerity, in the steps to be taken. Basically, ensure that the economic social rights are in place, which definitely they have not been. But also, as was raised by Benedict, what are the indicators? How do we actually monitor and follow the financial flows from Europe, from the EU to member states? How do we measure that, follow up on that much more carefully? I sat in on the high-level task force on Roma in 2010, following the Roma discussions in the summer 2010, and where we looked into where did the funding go that came from Brussels to member states in relation to the Roma, and that was just that. And there were absolutely zero trace, and we couldn't see any reports of were these this funding actually used successfully or in. I'm not saying it disappeared into the wrong pocket, but there's definitely a very high risk that they are. So I would say there's a major issue here that should be pushed, and that is monitor the flows. Also, for what Benedict said, that this is maybe also what keeps certain political groups alive. The Fundamental Rights Agency is moving ahead now with very powerful interactive maps coming out of all the surveys and the work, where you can start compare the situation on a number of different issues, where you can say it could be, let's say, a 2015 way of monitoring the situation in member states. So on the Fundamental Rights Agency, I would say push for a stronger mandate, make the annual report part of the rule of law cycle that the Council has announced that they will enter into. There should be a solid report based on objective, reliable data collected by the Fundamental Rights Agency to enlighten the discussion in the Council. Give the a stronger mandate in relation to more grave incidents. We did that in 3 cases. We made a report on the Roma attacks in Italy in 2008 in Ponticelli. We made a report on the extreme situation in Greece on asylum coming in. And we made one in 2013. I noticed it has not been mentioned. Unfortunately, a very strong report on extremism in Greece and Hungary, where we really try to highlight what is at stake. Finally, in relation to the agency, I would say give it a mandate in relation to Article 7. Just to wind up, at the national level as well, much more can be done. We have equality bodies, we have data protection officers, all established based on EU directives. When we looked into them, we have made a number of surveys. They are lack independence, they're poorly funded, their mandates are weak, etc. It's an appalling, not a very comforting picture we see. We can do much more. We should insist much more that these democratic institutions that have been established, they should function, they should reach out to those most vulnerable in our society. They should address the real issues in our communities. Some of them do, a lot of them don't. So basically, I would wind up by saying, let's have a stronger vision for Europe, a vision which is now slowly emerging in this field that I see coming up more and more, is the open, inclusive Europe respecting fundamental rights. So an open society, inclusive society within a fundamental rights framework. I think maybe that's the sort of vision we will all work much more focused on, because it is. We need much more knowledge broadly about what are the possibilities within the Union. We need much more joint up action, both horizontally and vertically. Horizontally between the institutions, for example, the different bodies at the different levels, but also between the national and the EU level, and for that sake, the Council of Europe level. It's far too scattered, uncoordinated, turf battling, instead of actually seeing, let's work together and try to push some of these issues that we are discussing. So this would be my words, and I know I played a little bit into the next agenda, namely what can we do, but sort of a bridge from this panel to the next.
Yeah, thank you very much. It was anyway very important and very